Okay, so once again, I suspect I've gone over time for these recorded lectures. I hope you forgive me. I hope you put me on chipmunk speed and that you manage to listen to me in significantly less time than it takes. It's just, I don't know why it's so hard for me to do, but it is. So this will be the last of the recorded videos for this week, and we'll deal with other things in the tutorials. But the focus here is going to be on the unfair contract term provisions. So these come out of the Australian Consumer Law, which itself is a schedule to the Australian Competition and Consumer Law. And I think that these are important because so many of the types of terms and conditions that you'll be thinking about for your assignment are likely to be terms that are standard terms and consumer-facing terms. And you'll be using these contracts to mitigate risks. So it's important to understand the limits that the law imposes on doing that. The provisions as they currently stand have been in operation since November 2023, so that's in the current form. Now, versions of these provisions have applied to consumers for a much longer time, but since November 2023, they've also applied to small businesses. There are also similar terms in the Australian Securities and Investments Commission Act, the ASIC Act, which are relevant in relation to securities in particular. We'll focus on the Australian Consumer Law, but this next slide here, which really is there to show you how serious these laws are, it actually shows the penalties under the ASIC Act as well as under the Australian Consumer Law. So as you can see, companies that breach this law are subject to significant penalties. So it's the greater of $50 million or 3 times the benefit that they got from the unfair contract terms conduct, or 30% of the company's adjusted turnover during the breach period, so a minimum of a 12-month period. So basically $50 million is your minimum amount of money there. It's going to be the greater of those 3. And individuals who are involved in the contraventions are up for $2.5 million. So there's significant amounts of money. You can see it using the penalties regime. So at 2024, actually I haven't adjusted that. Those numbers are usually adjusted as at July 2024, and I'm recording this in August 2024. But let's say, look, it's over $13 million. And again, that will be your minimum, and it could be as much as $555 million. So the first question you have to ask before we worry about whether these terms provide or not, whether a term is unfair or not, is does it actually apply? So first question we need to ask ourselves is the contract a standard form contract? So contracts that are prepared by one party that contain a standard set of terms that the counterparty, so the customer, in most circumstances it'll be a customer, but not all. So where the counterparty has little or no opportunity to negotiate. So in assessing whether a contract is a standard form contract or not, the courts will have regard to a range of factors, and they include whether the business has a dominant bargaining position or in its dealings. So whether that's the business that is providing the terms, whether the contract was prepared by the business prior to contractual discussions beginning, whether the counterparty has an effective opportunity to negotiate, or whether the contract was offered on a take-it-or-leave-it basis, whether the terms of the contract take into account the specific characteristics of the counterparty or the particular transaction, and, of course, the number of times that the business offering those terms has entered into the contract on the same or substantially similar terms. Contracts can still be considered standard even if the counterparty is given the opportunity to make insubstantial changes to the contract or to select from a range of term options, or if another counterparty to a similar contract was able to negotiate and make substantial changes to that other contract. If no one of these criteria apply, the court will have regard to all of them. It's also, the next step is actually, does this contract apply to a business, so a small business contract, or to a consumer? So this unfair contracts regime only applies to consumer and to small business contracts. Consumer contracts are defined in the law as contracts for the supply of goods or services, or a sale or grant of an interest in land to an individual whose acquisition of the goods, services, or interest is wholly or predominantly for personal, domestic, or household use or consumption. The small business contract definition itself has been significantly expanded since November 2023, or with effect from November 2023. Under the Australian Consumer Law, these are contracts for the supply of goods or services where at the time of entering into the contract, at least one party employed fewer than 100 full-time equivalent employees. So that used to be 20, but now it's under 100, and has an annual turnover of less than $10 million. And that's an or. 100 employees or $10 million. One of those, and you are in either of those apply, and you are dealing with a small business. The ASIC Act basically looks at it from the point of view of the value. So the upfront price payable under the contract is less than $5 million, and at least one party to the contract has fewer than 100 full-time employees or has an annual turnover of $10 million. So the next question, so if we've got a standard form agreement and the unfair contracts terms regime applies to the contract because it's a consumer contract or a small business contract, the next question becomes, are the terms unfair? So the substantive test as to whether a term of a contract falls within the unfair contracts terms regime has been consistent for some time and has been consistent since before November 2023. And basically what it looks at is that terms will be deemed to be unfair if they cause significant imbalance in the party's rights or obligations. The term is not reasonably necessary to protect the legitimate interests of the party advantaged by the term and would cause detriment, financial or otherwise, if it was relied upon. In assessing whether any of the terms satisfy these elements, companies need to have specific regard to the contract as a whole, so the combined effect of the term being considered together with all of the other terms in the contract, and the transparency of the term, as these are the essential considerations that a court's going to take into account when determining whether a term is unfair. So businesses need to keep these factors in mind because the regulators and the courts have already identified categories of high-risk terms. So these include terms which limit or exclude the liability of one party, which provide for wide indemnities or automatic rollovers of the term, or which give one party the right to unilaterally vary or terminate the contract without reasonable cause. So if you want to recommend that the business that you're working for limits its risk in relation to a particular AI, big data or blockchain technology by including disclaimers and limiting or excluding the liability of the company for risks associated with that technology, or which provide for broad indemnities in relation to any loss or damage that is suffered by you as a consequence of the use of these technologies, or which automatically roll over the terms without you necessarily paying attention to what those terms are, or give you the right to unilaterally change the terms of the agreement at some point, then you are at risk of those terms being unfair contract terms. And so if your customers are consumers or small businesses, or you're otherwise entering into agreements with consumers or small businesses, there will be a risk. Now, each time, those terms will be considered on a case-by-case basis, and they might not be considered unfair in every circumstance. It's going to be important to really look at the high-risk terms carefully and to ensure that you're getting legal advice in relation to those. If you're not a lawyer yourself, it is. I'm not going to spend any real time talking about this risk allocation piece because I just truly have run out of time. I just want to point you to the material that is on Canvas in relation to this. Basically, there's a really good exercise there that will help you identify stakeholders and determine the different types of contracts that you might be using for if you've got some kind of AI development or use. I think the materials are really useful to help you address the potential risks, including things like data security, intellectual property rights, which we'll talk about in more detail in coming weeks, and compliance with the regulation, which we're talking about pretty much every week. There's a great case study, the Blockchain X case study, and it's a good way to start thinking about that, and you might be able to use that material for your assignment. There's a good table in there that's been created as a starting point. And of course, you're going to find that with the technology that you've identified for your assignment, that there'll be other and additional types of contracts that might be relevant. And of course, there might be things on that table that aren't relevant in your particular circumstance. So that's all I have for this week. It was a lot. Look forward to working with you in the tutorials. But in the meantime, questions, concerns, frustrations, compliments, you know where to find me. Cheers.